All right, everybody. Most everybody's here, so we'll get started. Does everyone hear me all right? Shoot me a thumbs up, maybe. All good? All right. You might be thinking that Mike Stinson sounds a lot like Derek Allen. Unfortunately, he wasn't able to make it, so I'm going to cover this one. Good news is that it is something I have quite a bit of experience. My pre-AGC days were in litigation, so I've handled a few, probably 100 lawsuits, and there's just certain things that I learned. My legal history before going to law school and practicing was basically Perry Mason reruns that my dad had on and Law and Order, and that was about it. So as you might imagine, it's a little bit different in real life. You don't win every case, and there's certain things I've learned that I think would be helpful to people that maybe haven't been through an actual piece of litigation before, because it is quite a bit more complicated, expensive, time consuming, those sort of things than TV or just looking from the outside, you might think. So as far as questions, if you have anything like that, feel free to unmute yourself and just ask them. You can type them into the chat box. There's also a button on your end where you can put your hand up. So all those are good. If you got any questions at any time, feel free to ask those. So to get started, again, this is just to kind of go through a lawsuit. These would be the civil side. There's two branches of the law, criminal and civil. This would cover civil. Criminal, I've never really done. It's somewhat similar, but a lot of important differences. But this should cover what most civil lawsuits look like, more or less. So you can break it down into 6 stages. We've got them there. You got pre-litigation. You got your initial pleadings, which is what starts a lawsuit. You've got discovery, which is kind of the fact-finding, interviewing people, that sort of thing. You've got the build-up to trial. You got the trial itself, and then you got some post-judgment issues potentially. So we're going to walk through all 6 of those, talk about what happens in each stage, what issues arise, how long it might take, and what the cost might be. And again, the cost is a little bit of a guess. Every case is different. So I tried to give a range there. It's, if you went to a contractor and asked how much does it cost to build a school, what kind of school, how big, how many students, where's it at, those type of things. So there's going to be a range. So just keep that in mind. So to get to the first part would be pre-litigation. Typically, you're not going to just think everything's going great and then all of a sudden you're slapped with a lawsuit. There's usually going to be some rumblings. You're going to have an idea that you might get sued, those sort of things. So one of the things you'll see, usually I'd say about 95% of the time before you get sued, you'll get a letter. It's called a demand letter from the other side. So most people in business, you've probably seen them. I've been engaged by so-and-so, and you did this despicable thing, and we don't want to file a lawsuit. And if you pay us this extraordinary amount of money or do this thing that seems a little outrageous, then we promise not to sue you. At that point, you're looking at potentially litigation. So 2 things to probably do at that point. One is evaluate the case. Start getting your documents together. If you weren't personally involved with it, talk to the people that might have been. Just kind of get an idea of what you're getting into, because it's really important at this stage to figure out, does it make sense to just tell them to pound sand and they can sue you if they want and you'll deal with it that way? Or does it make more sense to try and resolve it early? Most of the time it does make sense to try and resolve it early. And you can actually nip cases in the bud before they ever get into litigation. And in my experience, if there was an opportunity to do that, it was well worthwhile, because as soon as you get in a lawsuit, you start paying lawyers. So the pot of money that's available to figure out a suit, some of it starts going to lawyers on day one. So if you can kind of put that money into a settlement package, there's often an opportunity to do better if you can settle things before a lawsuit at all. Your options for settling a case when litigation's brewing, but maybe no one's sued each other yet, there's informal. Pick up the phone, talk to the person, see if you can figure things out. Another decision-making point is, does it make sense to get an attorney right now? I think the factors that go into that are, does the other side have an attorney? There's no obligation to get an attorney in the pre-litigation phase, but if the other side has a lawyer, If you're getting a 15-page demand letter and they look like they're serious and they're ready to go, it makes sense to consider getting a lawyer at that stage for a couple of reasons. One, a good lawyer is going to help you with that case evaluation piece, know what you're getting into. We'll be able to work through some of the legal theories, estimate what your exposure might be. Sorry about that. And if the other side's got an attorney, it's just, in my experience, it's unlikely that they're going to settle with a party that doesn't have an attorney, because they feel like they're ready to go. They have someone that knows what they're doing. They've already paid them money, and they're probably unlikely to settle with a party that doesn't have an attorney because they think they have an advantage. So unless they get very, very good terms, essentially everything they want, they're probably less likely to settle. Another possibility is you can talk to the other party and say, hey, let's keep this out of the court system and let's go through formal mediation, formal arbitration, and just try and, we have our disagreements, but let's stay out of the court system. So there's two paths there. One is arbitration, which is basically a private court system. So some of the advantages of arbitration are that it keeps you out of the court system where most things are public. Any document filed for the most part is going to be public, but you might not want to do that. With an arbitration, it's going to be kept private. Another advantage of arbitration is if you get in the normal court system, you're going to get a judge assigned to your case. And that judge might have been a public defender, all sorts of things. And they might not know anything about construction whatsoever. With arbitration, you can agree with the other party. Let's say it's a construction dispute, that you want someone that knows about construction hearing the case, because there's certain things you learn. There's industry practices, those type of things that someone experienced in construction is going to be able to take into account, and maybe someone, the judge you get in the public court system, might not know any of that thing. And now there's pros and cons, but those are some of the good things about arbitration. Arbitration is binding, however. So you basically put your case in front of that arbitrator and they make a ruling and you're stuck with it. So that's one of the downsides, is that you can't appeal. Maybe the person got up on the wrong side of the bed. They missed a piece of evidence that you think they should have taken into account. In the normal court system, you can appeal that and potentially get that corrected. In arbitration, the arbitrator is given a lot of leeway, so they can screw up pretty bad and you're stuck with it. Again, that can be for better or worse, but that's something to keep in mind. The other option is mediation. So you can mediate the case before you get to litigation. And what that is the mediator can't make either party do anything, but what they do is use their experience. Typically your mediator is going to be either a very experienced attorney in the area or a retired judge. And they'll take a look at your case, they'll meet with both parties, and they'll try and help you come to a resolution. But at the end of the day, they can't order either side to do anything. They can't make either side do anything, but sometimes it can be helpful to have an actual retired judge say, if this case was in front of me and I had to decide it, here's what I'd be looking at. And that's a way to get rid of the case before litigation. And like I said, I'm a big proponent. If you can get a case resolved sooner rather than later, that's a good thing. You're saving on stress, you're saving on time, you're saving on legal fees. Some cases it's just not going to happen, but if there's a possibility, I think it does make sense to reach out to the other party and see if you can resolve the case out of the court system, resolve it in a month or so rather than years. There's just a lot of benefits to it. And it's usually worth a try. If nothing else, even if you can't resolve it, you do learn quite a bit about what the other side's position is, what they're actually looking for as far as money. And, you can just get a better picture of the litigation. So even if it doesn't work, I found it can be quite valuable in narrowing the scope and seeing how far apart you really are. And then finally, I talked about this a little bit, is whether to hire an attorney. I'd say if the other side has an attorney, you got to think about it pretty hard. If they don't, and you can just settle it business person to business person, not a lot of harm in that. One thing I would recommend is try and do, especially when you get into the nitty gritty of negotiation, try and do it over the phone. I think you can be a lot more candid. You don't have to worry about something you write coming back to bite you. So try and do quite a bit over the phone to the extent you can. So let's say you try pre-litigation, and on the right here, you'll see a sample demand letter. This is a pretty famous demand letter from the mid-70s. I'm not sure how well you can read it, but basically an attorney that attended Browns games had some concern about paper airplanes, and he was letting the Browns know that if he gets hit in the eye with a paper airplane, he's going to come after him. This letter itself is not too famous, but the response is, which you'll see on the next page here, slightly not safe for work language. I'm not sure if you can read it here, but Dear Mr. Cox, attached is a letter that we received on November 19th, 1974. I feel you should be aware that some asshole is signing your name to stupid letters. So that one cracked me up a little bit. But let's say you do get sued or you're suing somebody. How does the case actually start? It starts with a complaint. Any civil case, this is how you get it started. And what you're going to find in a complaint is, here's who the parties are. Here's what happened. Here's how the other side wronged me. Here's the legal theories that I think I can collect on. They breached their contract. They're negligent. Whatever it is, you lay it out in there. What'll procedurally happen is you file that with the court, and then you have an obligation to serve that on the other party. So when you receive this, let's say you're a defendant, you'll receive it. You can see that stamp up in the upper right corner that shows that it was filed. You'll receive this, and in my experience, most clients get it, and they usually want to go ballistic because it's full of it's the other side's story. There's going to be lies in there. There's going to be mistruths. It's a pretty hard thing to read when you're getting sued, because you want to tell your side of the story pretty quickly, and the complaint is a very one-sided document. But once you receive that, you have 20 days in Wisconsin to file an answer or a counterclaim or both. So what an answer is, you can see there's numbered paragraphs there. You go through each one and you admit it or you deny it. So usually one will say the party is located at this address. The defendant is located at this address. You could say, I admit that. That's where I'm at. And then maybe another one says they defrauded me and they lied about this, that, and the other. You deny those. And then that gives the court an idea of, so once the court has the complaint and once the court has the answer, they can go through and see, all right, the parties agree on these facts, they disagree on these facts. The court gets an idea of what's at issue. Another thing that strategically I pretty much always tried to do is, if my client got sued, I told him to think really hard about what did the other party do that you can get counterclaims against them. Think back, maybe there's some things that you were willing to let slide, but I always found it a strategic advantage to having counterclaims against the other side, because then they've got some skin in the game. So that would be part of your answers. You'd go through theirs and say, all right, this is a lie, that's true, this is a lie, we dispute this. And by the way, they did us wrong in so-and-so way, and file a counterclaim back to them. And now the counterclaim doesn't have to be related to their claim. It just has to be the same party. So they might be suing you about, you finish a job a month after you promised you would. You can countersue them for, a bill they forgot to pay 5 years ago. It doesn't need to be the same exact issue. So like I said, I always tried to tell my client to think hard, ask around, what can we sue them back for? Then it puts some skin in the game, and you get to play a little bit of offense too. In my experience, most clients want to get going really quick. As soon as they get this complaint, they want me to get in front of the judge so that we can tell our story. Not really the way it works. It's a pretty slow process. There are some cases where there is some action really early in the case. So the most common example, well, let me back up. In most cases, a side is asking for money. That's what the court system, that's really, in a lot of ways, what they can do is award money. So if something happened, if there's an accident or someone breached a contract, what's happened has happened. It's not going to get worse. It's not going to get better. It might take a year or 2 or 3, but at the end of the day, an award of money is going to be made, or it's not. But in some cases, the situation, if you let it brew or play out for 2 or 3 years before the judge makes a decision, the classic example is, if let's say the government wants to build a highway and they're going to bulldoze my house, and I don't think they have the right to do that. Well, if they're going to bulldoze my house tomorrow, it doesn't do me a whole lot of good if that happens. And then 2 years from now, a judge comes in and says, yeah, we took a look at it. They probably shouldn't have bulldozed your house. Well, I don't have a house. So the lawsuit didn't do me much good. So if it's a situation like that where something's going to happen very quickly that even if someone was wrong, then they end up winning the case, they're going to lose because the thing they're fighting for is already gone. Then you can ask for relief very quickly in a case. Where you'll typically see this with businesses is when you have a key employee that, you get an email at 5 p.m. I'm quitting. I'm going to work for a competitor tomorrow. You're able to go through your computer system. They download your client list. They're calling clients, or they're basically trying to steal a bunch of your intellectual property, move it over to the new place. That's where you can go into the court and say, hey, you need to stop this right now, because if they're able to take all that information to a competitor, you can say I win the case, but I'm done. I can't make it a year or two if you let them do that tomorrow. So that's usually the only case. There's some other exceptions, but usually in the employment context, that's one where you can get in court within usually a day or two of filing your complaint. And the judge will make the process for that is the judge will hear everybody out. The judge realizes parties have maybe only had a day or two or a week to put their case together. So they'll make a pretty quick decision. They'll say, come back in 3 weeks once you've had a little bit more time to prepare, but I'm going to make a decision today. Come back in 3 weeks when you've had more time to develop the case. We'll redo the hearing because maybe I missed something. Maybe one party got some information that wasn't available to them right away, but now they're able to get it after a couple of weeks. I'm going to rehear it. So there is a possibility to move pretty quickly, but in most cases, if there's nothing drastic that's going to happen in a week or two, you file this answer, you file this complaint, you don't really hear from the court, and you move into the discovery phase. As far as costs here, to get through the complaint, to get through an answer, potentially a counterclaim, again, it depends what type of case you're working with, but this is pretty much the first 2 to 3 months of a case, and your costs are likely $5,000 to $20,000, somewhere in there. If you're in that employment case I was talking about, those fees are going to be a lot higher because you're basically condensing what might be a year or two long case into a month. So that number is going to be quite a bit higher in that circumstance. But in most cases, you're looking at $5,000 to $20,000 just to get through sort of the laying the ground and letting the court know that there's a court case going on. Court basically leaves you alone, leaves the parties alone unless either party asks for some emergency relief, and then you get into the discovery phase. Discovery is, you probably spend 80 to 90% of a lawsuit in discovery. And what discovery is it is fact finding. When you're in a lawsuit, you've got the documents on your side, but there might be emails on the other side. There might be documents that only the other party has access to. You're entitled to all those in the court system, and you're entitled to ask for them. And most people are surprised by how broad those requests can be. The legal standard is you can ask for a piece of information from the other side if it's relevant to the case, or it potentially might lead to relevant evidence, which is extremely broad. So I've had cases where a business owner will have their wife subpoenaed, and it's like, well, why are you bringing the wife into it? she doesn't work for the business. She doesn't know anything about it. Well, maybe the guy went home and was telling her about it, and now she'd have information about things that her husband told her. Could that lead to relevant evidence? Probably not, but maybe. So judge might let that deposition go through. I got the types of, at the beginning there, the types of way you can get information. So one is document requests. If you've ever been part of a lawsuit, you almost certainly got a document request, and those are numbered things. I want to see your books for the last 5 years. I want to see every email that this employee sent regarding so-and-so issue. I want to see every text. I want to see, you name it, and that will be in those document requests. And like I talked about, the standard is extremely broad, so most likely they're going to get those. And if you're suing a competitor, if you're suing, someone that you might not want to have that information, a judge typically is like, tough luck. You're in a lawsuit. The way we've decided to design our system is that, you got to be an open book. So this can be a pretty painful thing, and you might have to turn over documents that you'd prefer not to. The other one are next category are interrogatories. So document requests are turn over these sets of documents. Interrogatories are written questions to the other side that they've got to answer under oath. So these are typically used, state all the owners of your business, state how much, those type of things, just anything you can think of as a question, you can put it in there in writing. The other side's got to respond to them. Typically, they're not very helpful because the other side's lawyer fills them out. So questions you might think would be very simple to answer, once you get them in a lawyer defending a lawsuit's hands, they send back a word salad that you can barely understand. So they're not very good to get to the substance of things, but they can be useful to figure out, all right, who are the other owners of the business? Who was the business employing at the time of, the occurrence that led to the lawsuit? Those type of things that are pretty basic. They're useful for that, but you're going to get some of those. The other category, probably the most valuable type of discovery, in my opinion, is a deposition. So what a deposition is, it allows you to interview anyone you want as part of your case under oath. So unlike the movies where there'll be a surprise witness and they're being examined by the attorneys, and there's this shocking piece of information that comes to light, that doesn't happen in the real world, because if they're an important witness, if you're going to put them on as a witness in trial, you've already deposed them. So you've asked them every question you wanted. You've got a transcript of it. So you know what they're going to say. That's one of the rules of being a good trial attorney, is you never ask a question in court unless you already know the answer to it. And that's because the reason you know the answer is you've already deposed them. You've already asked that question. So either they say what they said in the deposition, which is fine, or they don't, in which case you hold up the deposition transcript in court and say, all right, well, I asked you this, 6 months ago and you gave a different answer. Why is that? And then they've shot their credibility. So depositions are very important. I've got a small clip here to kind of see how they operate in practice. If I can pull this up. And the practical reality of depositions, aside from getting information from your case, is they are one of the few times when you are with your client, with the other side, and with the other side's attorneys. So there's a little bit of showmanship to it typically. And what's important about it is there's no judge there. So you can see the screen here. You'll notice there's a court reporter in the background. There's the two lawyers in the suits, and then the witness is the guy in the blue shirt. So you can put on a little bit of a show for your client because the judge isn't going to ever see it. And what's important about this too is there's only a transcript at the end of this. There's very rarely a video. So you can act a little bombastic, show off for your client a little bit in a way that a judge would yell at you, but there's no judge in a deposition. So these can get a little rambunctious. I always thought they're pretty fun, but that's just something to keep an eye on. If you're the one being deposed, the other lawyer's most likely gonna mess with you, yell at you, those sort of things. So here's a little bit of a clip. This is a case from Ohio from a few years ago. Now these are actors, but everything they're saying is right out of the deposition transcript. So this isn't the actual parties, but their script is right from it. And it just kind of shows how these can go and how there can be some gamesmanship. The key issue in this case was, I believe, whether the recorder's office was charging too much for copies. So what the lawyer on the left's trying to do is, as you'll see, figure out whether the office had a photocopy machine. And I would like to say this is a sort of extreme example, but I've seen something like this many times. So let me.
Being in some other building somewhere?
Yes.
During your tenure in the computer department at the recorder's office, has the recorder's office had photocopying machines?
Objection.
Any photocopying machine?
When you say photocopying machine, what do you mean?
Let me make sure I understand your question. You don't have an understanding of what a photocopying machine is?
No, I want to make sure that I answer your question correctly.
Dave, I'll object to the tone of the question. You make it sound like it's unbelievable to you that he wouldn't know what the definition of a photocopy machine is.
I didn't ask him to define it. I asked him if he had any.
When you say photocopying machine, what do you mean?
Let me be clear. The term photocopying machine is so ambiguous that you can't picture in your mind what a photocopying machine is in an office setting?
I just want to make sure I answer your question correctly.
Well, we'll find out. If you can say yes or no, I can do follow-ups. But it seems if you really don't know in an office setting what a photocopying machine is, I'd like the Ohio Supreme Court to hear you say so.
I just want to make sure I answer your question correctly.
There's different types of photocopiers, Dave.
You're speaking instead of... You're not under oath. This guy is.
I understand that, but I understand what his objection is. You want him to answer the question. I don't think it's fair.
It's not fair?
It's not a fair question. A photocopy machine can be a machine that uses photostatic technology, that uses xerographic technology, that uses scanning technology.
I don't care what kind of technology it uses. Has your offices... We don't have technocrats on the Ohio Supreme Court. We've got people like me, general guys...
Objection.
Or gals. I'm not really very interested in what the technology element of it is. I want to know...
That's what's at issue in the case, Dave.
Not in my judgment. Do you have photocopying machines at the recorder's office? If you don't know what that means in an office setting, please tell the court you don't know what that means in an office setting to have a photocopying machine.
I would like to answer your question to the best of my ability.
I'm asking you to answer that.
So if you could explain to me what you mean by...
I'm not going to do that because I want to establish on the record that you really don't know what it is. I want to establish that. Now, do you know what it is?
I'm sure it's been used. I didn't say I remembered a specific instance.
All right. But you have a general understanding that people have used the term photocopy within the recorder's office in terms of something that could be done there. Is that true?
I'm sure it's been used. I don't remember a specific instance or how it was used. I'm sure it's been used.
And is it fair to say that it's been used in terms of being able to copy one piece of paper onto another piece of paper using a machine? No? Not sure of that?
I'm sure it's been used. I don't recall a specific instance in which it was.
Do you have a secretary?
No.
Does anybody there have a secretary?
Yes.
Have you ever heard a secretary use the term photocopy?
No.
Have you ever? Do you have machines there where I can put in a paper document, push a button or two, and out will come copies of that paper document also on paper? Do you have such a machine?
Yes, sir.
What do you call that machine?
Xerox.
All right, so that gives you a little bit of an idea of it, what can happen with a deposition and when you're trying to get someone to determine whether they know what a copy machine is. I had a big one, probably the funniest one I ever had was, I just asked what the guy's name was. And I thought that was a pretty straightforward question. You usually start depositions with something like that. And he fought me. He said, I don't know. I wasn't there when I was born, so how can I verify what my parents named me? So we went round and around for about the first 15 minutes of, you know, how I could get him to say his name. That one ended, something you can do during a deposition is call the judge and say, here's what's going on. And the judge gave him a little bit of an earful. But that can happen. Like I said, a lot of gamesmanship and depositions. They're not particular. I've only been the one asking the questions, not been the one answering them, but for the people in the position to answer them, typically they usually kind of want to settle the case as soon as they're done with that because they don't want to go through it. They don't want to go through it again. One thing I do want to mention that I forgot to mention the first time around is, if you go back at the initial pleadings, most people want to get that lawsuit done very quickly. There is a mechanism to get rid of a case very early based only on the complaint. So it's called a 12B6 motion. And what it essentially is you can go to the judge and say, all right, even if everything they say is true and you give them every single benefit of the doubt, there's nothing here. There's no case. They're very hard to win that way, but sometimes those type of things do come up. And typically it would be in a case where the parties don't dispute what happened. They just dispute what the legal ramifications are. So to use an example out of the news in the last week from the Supreme Court, there was a case, there's a few consolidated cases about whether you could fire an employee for being gay, whether you could do that under federal law. And everyone agreed what happened. The employer said, yes, that's why we fired this person. We think it's legal. The other side, thinks it's not. The employee thinks it's not. So that's one where you actually wouldn't go through discovery or anything like that because everyone agrees on what happened. So a lot of the cases you'll see in the Supreme Court, they never went to discovery because everyone agrees on the facts of what happened. They just don't agree on the application of the law. So if you're in a situation like that where both parties agree on every single thing that happened, there's no factual disputes, you might be able to get rid of this case pretty early in the first 2 or 3 months rather than years and years. But those cases are pretty rare. Most lawsuits, certainly in the construction setting, are going to have factual disputes. You're going to have the thing where, we had to do this and we were supposed to get a change order. We didn't get a written change order, but the guy from the other side said, don't worry about it. We'll sign it when it comes through. And then you get into the lawsuit. Oh, I never said that, or he didn't have authority to say that. And now you've got this he said, she said. You can't get rid of a case like that early. At some point, if there's a factual dispute, you can't get rid of it at the initial pleadings because, like I talked about, when the judge is thinking about whether to dismiss a case early, they have to assume that every single thing the plaintiff said is true. And if there's ever any, murky area or there's, maybe there's a fact left out, they have to assume that goes in the plaintiff's favor. So as you can imagine, it's pretty tough to win a case when the judge will only hear from one side. They'll believe everything they say and they'll give them the benefit of the doubt everywhere they possibly can. It's just hard to get rid of it. So I think a lot of people try to do that early in cases. I think it's a mistake for most litigators. And I think the reason they do it is because clients are usually pretty hot to trot at the beginning and they want to feel like they're doing something. So if they bring a motion to dismiss the case, even though the lawyer knows it's a total loser, some might do it because number one, it generates some billable fees. And number two, it at least looks like you're doing something for the client. So I always push back when clients wanted to do it, but you'll see a lot more motions to dismiss early than I think there should be for the main reason that candidly, I think clients don't understand how futile they are, but it makes the lawyer feel a little bit better because they're doing something. But odds are in 95% of cases, you're not going to get rid of it that early. So after the discovery phase, you might have some motion practice where the other side's not turning over documents. Well, they don't need those, or those are secretive, or I don't really, why does my, spouse need to get dragged into this? You might have those type of disputes. So there might be some motions where you go in front of the judge and say, hey, they're not giving me these documents, or, they sent half their books over, but not the other half. And we think that there's these other documents. Please order them to send them over. There'll be a lot of that going on. Also during discovery, you'll retain experts. Pretty rare, decent sized case that does not have at least one type of expert. So during discovery, the type of experts you'll typically see are, you typically have a damage expert. Okay. I looked at the situation, there's this amount of delay or this amount of damage. And based on my experience as an expert in so-and-so field, I think that they've been damaged X amount of dollars. Oftentimes you'll have to, some of your damages are going to be, they're going to be guesses. They're going to be estimates. How much future profit did you lose? How much did losing out on this project really cost you? Those sort of things. And most of the time you're going to have an expert testify on that. You also might have an expert on, if it's a work site accident, safety experts on both sides. Well, actually, contractor did everything they were supposed to do. That's what one side's going to say. And then you're going to have an expert on the other side saying, no, I actually have been doing this for 20 years and they should have done this, they should have done that. So you'll have experts on the merits of the case and you'll have experts on the damages or lack thereof, depending on which side you're on. So those people are retained during discovery. A lot of the documents and information you get in depositions are to feed the experts information they need. And then the experts themselves can be deposed. So you'll depose witnesses, you'll just depose the other side's experts. So that's when those people will start getting involved in the case. And as my final bullet point says there, this is when you really start lighting money on fire. Discovery is an extremely costly, depends on the side of the case. I think if you have a civil case, even if it's small, even if it's straightforward, even if there's only 2 or 3 witnesses, you're probably not getting that to trial in less than probably a year and a half in Dane County. Some of the more rural counties, you can get in a little bit quicker, but count on at least a year. It's really hard to get a case from beginning to end in less than a year. Costs, again, if it's straightforward and maybe you don't have to take depositions, maybe you've got all the documents you need, this is still probably going to cost you 10 grand at a minimum. If you're in bigger cases, $1 million plus easy. The biggest case I ever worked on, $200 million case up in Minnesota. The legal fees during discovery were $44 million. And that wasn't the trial. That wasn't what experts got paid, any of that. That was just our firm's work during discovery. So this is the biggest part of your case. It's the longest time period. It's can be the most frustrating because you're exchanging information. You're not really moving the case forward very much. That's where you're going to spend a lot of time is in discovery. And that's why I'm a big fan of that pre-litigation or very early litigation, mediation, arbitration, those type of things, because if you can settle the case there, you avoid discovery. And again, my experience is most cases don't settle during discovery. Once you get to that phase, you're probably going to have to see it through to the end, because parties, they want to see all the information. If they've only seen half the information, if they're only half the way through discovery, they're probably going to want to see it out before they try and settle the case. So unless one or both parties just totally run out of money, you're probably going to have to go through the whole discovery process. There's flash points when cases settle. One flash point is right before it gets filed or right after it gets filed. And then usually you don't see a lot that settle after 6 months or a year. They usually settle at the end of discovery, right before the trial or they go to trial. But if you're into discovery, you're probably going to have to see it through, and it's expensive. Your employees might be deposed. You might be deposed. It's tough. It's not a lot of fun. So if you can get rid of the case before discovery, that's a good thing. So you go through discovery, you've got the information, you got all your documents, you've got your experts ready to go, and you're approaching trial. So that'd be your next phase is your final sprint to trial. So what happens there? The first thing that you'll see in almost every case is something called summary judgment. So what summary judgment is, you can compare it to that motion to dismiss I talked about, based only on the pleadings, where the judge has to take everything in the complaint as true, give all reasonable inferences to the plaintiff, those type of things. Very high standard, very difficult to do. Summary judgment is can actually be quite a bit more effective, because at that point you got to come up with your actual facts. So if you said something in the complaint, after discovery, you got to be able to prove that. So what summary judgment is judge, we've spent a year, we've spent 3 years, everyone's had total access to every piece of information that's out there. And we as the defendant, they don't have a case. They thought they did. They put a bunch of stuff in the complaint. We've proved it wasn't true. Here are the actual facts. And based on what the facts are now, what we know, what we've developed, they don't have a case. There's nothing for trial to be done, because maybe in their initial pleading, they claimed I blew a red light and hit somebody. Okay. They don't have a witness saying we went through discovery. They have no witnesses that are going to say that. They have no video footage of a red light. There's no one saying that I ran a red light anywhere. So there's nothing to have a trial over. That's what summary judgment is. So if there's competing factual stories, you got one witness saying, yep, I saw him blow the red light. Another witness saying, nope, it was, he stopped at the red light. Then you've got to have a trial. But if you only got the one witness after discovery that's willing to testify about whether I blew a red light or not, if there's only one out there, you don't need a trial. So summary judgment is essentially saying, put the facts on the table. If one side can't support their case, it should be dismissed. That's one where you'll see settlement sometimes, is the judge might come in and say, I just don't see much of a case here. Or they sued you under 8 causes of action. I dismissed 7 of them on summary judgment. Then maybe that's a case that might settle, because one party's basically had their case turned into Swiss cheese. So summary judgment is a very important thing that you'll see in basically every case. It can be on the whole case, or it can be on certain issues of the case. So you might say, there's no doubt whatsoever that all the witnesses agree with my side, but we don't know what the damages are. So you might get summary judgment on the merits of the case. Yes, you did the wrong thing, and now we're going to have a trial on damages. Or vice versa. We can prove there's not a factual dispute on what the damages are if there was misconduct, but we have to have a trial on whether there was misconduct in the first place. So summary judgment is an important thing, happens at the end of discovery. and you basically got to put your cards on the table and say, we have a case here. If you didn't do mediation at the beginning of the case, and sometimes even if you did, the judge will almost always order the parties to try it again. Okay, you've been through discovery. You guys have been hacking this out for the last 2 or 3 years, 5 years. I'm going to send you to a mediator. The judge doesn't have authority to send you to arbitration. And again, remembering the difference, an arbitrator can actually make an order, a mediator cannot. But they'll send you to a mediation. Typically, most judges have a favorite mediator. It might have been a colleague of theirs that they were judges with that's not retired, but they'll send you there. They want you to give it one more go to see if you can settle the case. So typically you'll see mediation. And at this stage, I would say probably 70% of the cases I worked on ended at mediation after discovery. That's a very prime time to settle cases because a lot of the cards are on the table. And trials are very expensive. So you usually have a pretty good idea, a much better idea of how strong your case is at the end of discovery. Both sides have a lot better idea. They got more information, so they're much more likely to settle at this point in time. It's probably the number one point in time the case is settled. You'll also at this point have expert reports. So experts have taken a look at the case and then they write up a report that summarizes how they're going to testify. Okay, here's the information I looked at. Here's what my expertise is. And I think that, the damages are X amount, or this party's at fault because they didn't follow this safety protocol, whatever it is. Both sides will have access to those expert reports. As you lead up to trial, you can ask the judge to not allow an expert to testify at trial. They're called Daubert motions. And what those essentially are is, well, this person claims to be an expert, but they're not really an expert, judge. So they're not going to help you out. They don't know what they're talking about. They don't have the expertise. You shouldn't hear from them at all. So you'll usually see that at the end, right before trial, is the parties trying to have the other party's experts disqualified because, like I talked about, maybe they don't have the qualifications. Maybe you can show that they were looking at wrong information. So usually try and get those thrown out. And then you start really preparing your witnesses. So the case I talked about was a $200 million case. We had, I believe, 25 witnesses sprayed all over the country. And that's when we as attorneys started flying out, sitting down with these people. Here's the theory of the case. Here's the questions we're going to ask you. Here's what the other party might ask you. Very time consuming for the parties themselves. A lot of what I've talked about previously, that's on the lawyers. There's obviously some work to be done for the clients or by the clients, but a vast majority is done by the attorneys. When you're doing trial preparation, the parties become a lot more involved themselves. And in a bigger case, if I expect a witness to be on the stand for half a day, 4 hours, which is actually not a very long amount of time. A lot of witnesses in big cases are on the stand for 2 or 3 days at times. I usually wanted to spend about 4 or 5 times is what I expected them to be on the stand, preparing them to be on the stand. So if I thought that they were going to be testifying for half a day, I wanted to spend 16 to 20 hours with them, me and them in a conference room going through the facts of the case. I wanted to spend 4 or 5 times what I expected them to be in trial. And then you start doing the math. If you got something that affects a large number of your employees or people at your company, you might have 10 or 15 people that have to take half a week out of work to prepare for this case. And obviously that doesn't even factor in the amount of money you're paying the lawyers to prepare those people. So this is when the most money gets spent the quickest, because it is all hands on deck. It's usually the last month to 3 months before the trial. The fees can be quite high here. The only reason they're lower than discovery is discovery can be 1 to 5 years. Here you're only in this stage for usually, I'd say, a month to 3 months. So that's the only reason that the gross number there is lower than discovery, but per day, you're really spending a lot of money. And what's tricky is usually what you're doing is you're trying to settle the case. You're hopeful to settle the case, but you don't want to be caught not prepared if the case actually goes to trial. The actual numbers on it are 99% of cases settle without a trial. So it's extremely rare to go to trial. But you don't want to count on being in the 98 or 99%, and then you end up being in the 1 or 2% and you're not prepared. So that's the dynamic there. And then After that stage, you're at the actual trial. Again, probably only 1 or 2% of cases ever get this far. A lot of cases, quote unquote, settle on the courthouse steps. I've had that a lot, where you fully prepare for a trial, you put in all that work, you're right about ready to do your opening arguments. The other party's attorney pokes you on the shoulder, sends you a text, hey, can we talk for a minute? And then you go in a conference room and settle it. So you did all this trial preparation, and then the case settles literally right before the trial's scheduled to start. If it does go to trial, there's a few stages. So the first one is opening arguments. That is, each side's attorney gets to go up there and say, here's what's going on. Here's what the witnesses are going to say. Here's our story. Here's why we're the good guys. Here's why they're the bad guys. And here's the amount of money we want. Or here's, judge, here's what we want you to do at the end of it. Or jury, here's what you're going to see over the next week or so. Here's the story you're going to hear. The other side does the other thing. Presents their case with oral arguments or opening arguments. Says everything that guy just said. Don't listen to him. He doesn't know what he's talking about. Listen to me. Here's actually what happened, and here's why we should win. So each side does opening arguments. Those are done by the lawyers themselves, and then the plaintiff goes first, presents their case. That's what most people will be familiar with, because that looks a lot like what is on TV. That's usually what TV shows is a trial. So you throw your witnesses up there. Your own lawyer has an opportunity to ask you questions, so they'll ask you questions. Then the other side has the opportunity to cross-examine all the witnesses. So it kind of goes back and forth. If I represent the plaintiff, I call up, the owner of the plaintiff's business. We talk about the history of the business and what happened and what led us to this lawsuit and that sort of thing. And then the defendant's attorney gets to question him or her about, what about this? What about that? Plaintiff goes first. Presents their case. That might take anywhere from half a day in a smaller case, up to a month, up to 2 months, just for the plaintiff's case, depending on how big of a case you got. So plaintiff goes first, then defendant presents their case. There are some cases where the defendant has their own set of witnesses. There's plenty of cases actually where the defendant never presents a case. They get their story in through the plaintiff's case. So if the plaintiff called all the relevant witnesses, the plaintiff's attorney got to question them. The defendant's attorney gets to cross-examine them. The defendant might go, we don't really have our own case. Jury, judge, you heard the case through my questioning of the plaintiff's witnesses. So the defendant has the opportunity to present other witnesses, to present new information. Sometimes they do, sometimes they don't. Depends on the case. And then closing arguments are what you see in the movies. Okay, here's what you've heard the last week. Here's what you've heard the last couple weeks. Are you really going to believe so-and-so? Are you really going to ignore this document? This is the most important document in the case. So when you go back in the jury room, this is what I want you to keep in mind. Very dramatic. Really good attorneys are really good at this. But that's it. And then it either gets sent to, depending on the type of case, some of them a judge themselves determines it. Other ones a jury does. Won't get into the distinctions of which one is which, but whoever's in charge of that, if it's a jury, they go back in the jury room, they discuss it for somewhere between 10 minutes and a month. If it's a judge, they'll usually sit on it. They'll say, thank you, everybody, but I got to think about this for a couple of weeks, couple of months, and then you'll get a written decision. So at the end of that, if you went through a trial, if you're one of the unfortunate ones that actually had to go through a trial, it's probably taken the trial itself a couple days up to a month to get to that point. You probably, like I said, if you have a very simple case that's kind of on a fast track, it might be 1.5 years from when it was filed to when you got to the end of a trial. Most cases I'd count on probably 2 to 3 years to get to that point. And then there's others that take 5, 6, 7 years to get to a trial. So that's the time you're looking at. Money. If you go through a trial, it's really hard, even if it's a simple case, even if there's only 2 or 3 witnesses. Was that there? Even if there's only 2 or 3 witnesses, it's going to be tough to get through a trial for less than $50,000 total. So when I was talking about if you can settle the case early, that's $50,000 you can throw towards potentially selling the case. If you go through the trial, that's money that a lawyer got, and that's a cheap one. I would say most pieces of commercial litigation that have some substance, you're looking at well into 6 figures if not pushing 7. So it's very expensive. It's very time consuming. It's very stressful. In my experience, people that are in the middle of a lawsuit, you wake up thinking about it, and you go to bed thinking about it, and you can't put a dollar amount on that, but it can be a stressful thing. So when people, especially very early in a case, when they're feeling good, they think they got the merits of the case on their side. I really tried to lay out to them, like, everyone wants their day in court. They're convinced that if they can get in front of a judge or a jury and tell their story, they're going to win, and they're kind of looking forward to doing that. At the beginning of a case, you might be 3 years away from that and $400,000 away. So it's not saying you shouldn't do it, but you should go in with eyes wide open, realize what you're getting into. So you got your trial. Your last stage is post-judgment matters. It's kind of unfortunate, but a fair amount of the time, getting the judgment itself is half the battle. A judgment is essentially a government-mandated IOU, okay? Party A, you owe Party B $500,000. Well, someone owing you $5,000 is a lot different than having $500,000 in your pocket. So this has happened to me a couple of times. You do a great job on the case, you're feeling good, you ring up a huge judgment. That other party turns around the very next day or the next week and declares bankruptcy, tries to wipe out your entire judgment. And a lot of times it happens. And it's not a fun conversation to have with your client. It's something you should keep an eye on when you are suing someone. If I win, do they have enough assets that I can get to that I'm going to get paid? So that's one thing to watch out for. Or on the flip side, maybe you went, you know what, we lost the case. We don't think it was fair, but we're not that big of a company. We can't pay it. There's, like you can come after me for $1 million, but we've got 2 trucks and a couple computers and a phone. So have at it. So it's something to think about, whether you're on the winning side or the losing side. Bankruptcy can be a big issue. One practice point on that is it was extreme. Almost every case I worked on, a party threatened bankruptcy during the case. So when you're doing your settlement negotiations, it was very common for them to say, well, even if you win, we're just going to file bankruptcy. 95% of the time, call their bluff. Okay, if that's what you want to do, that's the way we'll do it. But some companies actually go through with it. So it's that part of discovery I found very important was, yeah, you got to win the case, but you actually want to figure out, if we win and get what we want, can the other side even pay it? So part of discovery is getting into their books and seeing what accounts they have, what things you can get after, those sort of things. Appeal is a possibility. So that's one benefit, like I talked about, of being in the public court system versus arbitration, is that we do have a set of appeals. Here in Wisconsin, and most cases work the same way, most states work the same way, is you've got your circuit court, which is where the trial is at. Then there'll be a court of appeals, and then there'll be a Supreme Court. So those tend to be your tiers. And if you got a very unfair decision, if you got one that you think was wrong on the law, you are able to appeal that up the chain. Those are pretty time consuming and expensive, not as bad as a case at the circuit court level typically. But there's some expense to that. I think a minimum that you're going to spend on an appeal is $15,000 up to probably $100,000, somewhere in that range. And appeals are very time consuming. You don't have discovery. The record is locked at the trial court, so you can't add new witnesses. You can't add new documents. You have to use the universe of information that was at the circuit court level. But you can say, Court of Appeals, here's the universe of information. The circuit court looked at it, and they got the decision wrong. You need to look at the same information and do the right thing. That's what you're asking them to do. That can take, depends, but usually a year to 3 years to get through an appeal. So you can start to see how some of these court cases drag on. Is you might have a five years in front of the circuit court. Someone appeals, now you got another 2 to 3 years. Maybe they appeal it to the Supreme Court, and then you can end up with an 8 to 10 year court case pretty quickly. But appeals are tough to win. So vast majority of cases, it's not worth it, but sometimes it is. And then the third bullet point is collections. Probably wondering why there's horses there. It's probably one of my favorite stories. It was my first week as an attorney. I was at a big firm in Minneapolis, and they'd won a judgment against, it was actually a real estate developer that was robbing Peter to pay Paul all over the place. And we actually were able to get a judgment against him. And I think it was for, I'm trying to remember, it's like $300,000. And you can't get typically to someone's house. You can't get to their personal property. their clothes, their car. They usually get one vehicle you can't touch, but pretty much anything other than their house, their home, and their household goods you can get at. And if someone's got a judgment against you, you can either pay them the cash or they can start impounding your stuff and selling it. So this guy that we got the judgment against, he was kind of a jerk throughout the process. And the attorneys that I worked with learned that he had a herd of horses. He raised horses, and he had one that was his favorite racehorse. So they decided as payback that they were going to impound that horse. So this all happened before I got there. It was my first week, and I get a call. They took the sheriff out there. They impounded this horse, and they forgot that they didn't have anywhere to put the horse. So I got a call from the partner. Can you please figure out where we can put a horse today? And I thought, oh, this is weird. I didn't learn this in law school. So found a stable where we were able to put that horse up. Later learned that we got the wrong horse. They picked the wrong one, but that just there's a ton of them, and they all look pretty similar. I got 4 legs and a mane. So they took the wrong horse, but eventually we got the right horse, sold the horse, and paid the judgment that way. So collections can get it's its own area of the law. It can be sort of Wild West. But there's a big difference that I tried to impress on clients. Getting a judgment's one thing. Collecting on it can be a different one. So make sure that if you're investing in a lawsuit that you're going against a party that you can actually collect from. Like I talked about the time period here, if the other side loses and they cut you a check, you're probably going to get that within a month or so. If they got the money and, they're willing to do that, which a fair amount of defendants are, they realize that they lost the case and they'll cut the check and move on. But if you get going through appeals and bankruptcies, it might take 10 years from when you quote unquote won the trial before you see a dime, and your costs can be pretty substantial trying to collect on judgment. So again, it's really important if you're in a lawsuit with someone and they're judgment proof, meaning they don't have any money and you do, it's kind of an asymmetric situation, but it's bad that if they win, they're going to be able to collect off you, but if you win, you're not going to be able to collect off them. That could be pretty tough. So that's something you definitely want to keep an eye on. One final thing that I'll mention is actually a couple things. One is getting an attorney. If you are a corporation, you have to get an attorney if you've been sued. A corporation cannot defend itself in court with the president or the owner or anything like that, unless you're in small claims court. They can in small claims court, which is anything $10,000 or less. But if you're going in real court, you actually, as a business, as a corporation, as an LLC, need to have an attorney represent you in court. Can't represent yourself. Because theoretically, a corporation at the end of the day is really just a piece of paper. It's a fiction. So there's not really a person behind it. And probably the most important part of this is choosing an attorney. It's a couple things. One is you need to make sure and what's tricky about this, what I've learned being an attorney is if you don't have if you don't know an attorney, it's really hard to tell the difference between a good one and a bad one. What are you going to look at? A billboard? All the websites look the same. Everyone works for a powerhouse firm. Everyone's aggressive. It's just really, really hard to tell. So one resource would be something like the AGC or an attorney that you might know. Talk to them, because attorneys, once you're in the system, you learn pretty quickly who's good and who's not. But it can be hard if you've never had to go through that before. Experience is extremely important. Location is important. I know that I practiced in Evansville, which is in Rock County. And I did a lot of cases in Rock County and Greene County. And I know it was a benefit to my client, me being from Evansville, being sort of local. If some attorney walked in from Milwaukee wearing a $12,000 suit in Greene County Court in Monroe, I think the client thought it might be beneficial because it was a hot shot from the big city, charging them $600 an hour. But sometimes it didn't go over so well, in Monroe in a 2-room courthouse. So that's something else to keep in mind is if you're a Wisconsin company and you're getting sued in Georgia, you might have the best lawyer in Wisconsin on retainer, but you might want to get someone with an accent that's from Georgia, if that's where you're going to be. So, or even within Wisconsin itself, you might want a guy a man or woman from Superior if you got a case up north rather than the best lawyer from Madison. So that's something to keep in mind is especially if you get more rural areas. You know, there can be a little bit of tribalism there. So that's something to think about, is the geographic location of where you're getting your attorney from. Experience is good. And I think the biggest one is you really should meet with the attorney, because we come in all types. There's very aggressive, bombastic types. There's very scholarly, professorial types. There's people that try and get along with the other side. There's some that think their job is to make the other side as miserable as possible. And depending on the type of case you have, depending on the way you want to do business, those sort of things, those make a difference. So you should meet with at least one attorney. We're not all the same. Make sure that you've got one that's going to, you know, process the case how you want it processed, because your business it's a public facing thing for your business. And if you have a lawyer that's trying to burn things down and being nasty, that might bite you in some other ways. On the flip side, maybe you want a lawyer like that, but the personality makes a big difference. Level of experience makes a big difference. And then the geographic scope can make a big difference as well. So I'll leave you with that. Any questions before we log off? All right, well, very good. There's my contact information here. Please let me know if you have any questions at all. If you find yourself on the verge of a lawsuit, looking for litigator recommendations, want me to take a look at your case, anything like that, I'm here for it. And like I said, I've done a few hundred of them. No one would accuse me of knowing what I'm doing, but I like to think I learned a thing or two going through those. So I've been through lots of different types of cases.
I do have a question.
Sure.
Can you hear me?
Yep.
I'm confused as to what role the AGC's lawyers or staff can help us, and to what point. When do you counsel us that you need your own lawyer? I've looked at what you're presenting and what your problems are, and I can help you do this, this, and this. But when is the AGC's limits of their services done, I guess?
Sure. So one bright line is I can't represent you in court. I can't file pleadings, anything like that. So there's a bright line there. What I can do is basically everything in that pre-litigation stage. So case evaluation, I can actually, to the extent the member wants me to, engage in pre-litigation settlement discussions. So let's say you are in that pre-litigation phase, you do talk to the other side, and they're willing to go through I couldn't do an arbitration, but a mediation, I could represent you in that. So basically anything before it touches the courthouse, we can help you with. But there might be some issues where I hear them and I say, well, I theoretically could help you out with this. I just don't have the expertise level. So you're probably gonna have to reach out to another type of attorney. So basically anything before that doesn't touch a courthouse, we can help with, I can help with.
Okay. All right, that's helpful to know.
And then also, like I talked about, just from practicing in the area for a number of years, I think I have a good stable of referral sources. So it can be useful there. If, you're kind of flying blind trying to pick an attorney, I might be able to say, judging on this case and knowing your personality, maybe this person would be a good bet for you.
Okay. Yeah, I don't have any more questions, but thank you.
Yep, not hearing any. We'll log off now. We'll get the slides emailed out. Like I said, I'm always here, so reach out with any questions you've got, and everyone have a good day, and hopefully you never have to be involved with any of this.